there, and welcome to ProfDale's property video number 12. The subject is one of the most challenging in the law of estates and future interests, namely the rule against perpetuities. It's not so tough though, so let's dive in and see what we can learn about it. The first thing to say is what the rule does. And what the rule does is to make certain future interests void. When we say void, we mean that if a future interest violates the rule, it's like it had never been created. The rule squashes it like a bug and voids it, makes it as if it never existed in the first place. However, we have to be a little careful about this because only the particular future interest that violates the rule is void and not the whole conveyance. What we mean by that is that in the usual deed or will, there are usually some present interests and sometimes some other future interests in the same conveyance. And even if one of the future interests is void under the rule against perpetuities, the other future interests and the present interests are still perfectly valid. So it's almost always wrong to say, this deed or this will is void under the rule against perpetuities. What the rule does is to make some particular specific future interest void, and the rest of the conveyance is usually valid. So the first thing we need to do is figure out which interests are and are not covered by the rule against perpetuities. The interests that are not covered, of course, include all present interests. Present interests have nothing to do with the rule against perpetuities at all. It just doesn't apply to them. In addition, the rule does not apply to future interests that are created in a grantor. We've already learned what the three future interests created in a grantor are called. There's the possibility of reverter, the right of entry or power of termination, and the reversion. And the rule against perpetuities does not apply to any of those. The idea that it doesn't apply to possibilities of reverter and rights of entry has been criticized, but the common law is absolutely clear that it does not apply to any of those future interests created in the grantor. In addition, the rule does not apply to vested remainders, even a vested remainder that's subject to complete defeasance, unless it is to a class, in other words, a class gift. So the future interests that are covered by the rule against perpetuities include what's left, namely contingent remainders, all executory interests, and class gifts, even if they are vested remainders to a class. In addition, and this is a concept we haven't talked about before, the rule applies to options and rights of first refusal. These really aren't future interests at all, but the courts treats them as if they were future interests, and they apply the rule against perpetuities to options and rights of first refusal. We'll cover those a little bit later. We don't need to talk about them right now. So what do you do when you get a future interest and you suspect it might be subject to the rule? Well, the first thing you do is you go through the conveyance and identify each future interest that's in the conveyance. Sometimes there's just one future interest, sometimes there's more than one. You have to identify them. Second, you've got to determine if each one of those is a type of future interest to which the rule applies. Namely, it only applies, as we just learned on the previous slide, to contingent remainders, executory interests, and class gifts. So you determine whether the future interest you're looking at is one of the types of interest that the rule applies to. Finally, you've got to determine if it violates the rule by applying the rule to it. If it does violate the rule, you strike it out. You literally cross it out with your pencil. It's void. It's like it never existed. And so you read what's left as if that had been the original wording of the conveyance. So what does the rule against perpetuity say? How can you tell if a future interest that is within the rule is violated by it? Well, here's what it says. It's a little complicated, but it isn't really too bad. First, it says that a future interest covered by the rule is void unless it is certain to vest or fail within a certain time period. What is that time period? It's 21 years after the end of some life of some person that was in being at the creation of the interest. So that's the rule in a nutshell. A future interest is void if it's covered by the rule, unless it's certain to vest or fail within 21 years after some life in being at the creation of the interest. Now, what do we mean by vest? Well, for contingent remainders, we mean a remainder that was contingent has to become a vested remainder. It might do that before it becomes possessory. For example, if we said to A for life, then to B if and when B marries. Well, if B gets married, then B has satisfied the condition on the future interest. It's a contingent remainder before B gets married, but as soon as B gets married, it becomes a vested remainder. Now, it isn't possessory yet. It doesn't become possessory until A dies, but it now becomes a vested remainder, and if it will do that within 21 years after some life in being at the creation of the interest, then it's valid. In this case, it will do that within B's lifetime. We don't even need to use the 21-year period, and so that one is valid under the rule against perpetuities. But we determine that by determining when, how far in the future, it will become a vested remainder, because it is a remainder. Now, for executory interest, the rule's a little different. When we say vested with regard to executory interest, we mean when will it become possessory. We'll see examples of that in just a moment. So what do we mean when we say that the future interest has to vest or fail within 21 years after some life in being? Well, let's take an example. To A for life, then to A's firstborn daughter. Let's assume that A has no daughters when the conveyance is made. So we don't really know whether A will have a daughter or not. There are two things that might happen. Either A will have a daughter, and that daughter by definition will be the firstborn daughter, or A will die without having any daughters, in which case the remainder will fail. There will not be anybody, in other words, who is qualified to take the remainder. One of those two things is certain to happen by the end of A's lifetime, and because of that, we can say for sure that the future interest will vest or it will fail by the end of A's life, because A can't have any daughters after A has died. So that one is an easy one to meet the test of the rule against perpetuities, but it shows what we mean when we say the future interest has to either vest or it has to fail within the period allowed by the rule against perpetuities. Many times students say, well, who do you use as the measuring life? And the answer is you can use anybody you want to, as long as you're sure the person you're using was alive at the time the interest was created. That means that literally you could pick names out of the phone book. If you can make the future interest valid using anybody's life who you're sure was alive when the conveyance is made, then it's valid. And if you can't, it's void. However, as a practical matter, it doesn't do any good to pick names out of the phone book or use names chosen at random. It's only useful to try using the lives of the people who are mentioned or described in the conveyance. But you can try any of them as long as you're sure they're alive, and if you can make the future interest valid using any one of them, then it's valid. Well, now we're ready to try a few examples of the rule against perpetuities and see how it works. The first one says to A, so long as no liquor is ever sold on the premises, and then to B. Obviously, we have a present interest in A here and a future interest in B. What is A's interest? Well, based on the analysis that we covered in previous videos, we'd say that A has a fee simple subject to executory interest, and B's interest is, of course, an executory interest. Now remember, when we're talking about executory interests, we test the application of the rule against perpetuities by saying when will that future interest, that executory interest, vest in possession? When will it become possessory? Is there any time limit on how far in the future B's interest might vest, or in other words, become possessory? Is it certain to happen within A's life or within B's life? Well, if we go back and read the wording of the conveyance, it says, so long as no liquor is ever sold on the premises. So what that means is that long after A has died, long after B has died, if liquor is sold on the premises, A's interest will terminate and B's future interest, which now, if B has died, will belong to B's successors, will then become possessory. But you'll notice there's no time limit on it. It might happen long after A's life and B's life, and any particular period you want to imagine after A's life or B's life. There is no time limit on it, and therefore that future interest to B, that executory interest, is void. Now, when we find a future interest that's void under the rule against perpetuities, remember what we do is to draw a line through it and pretend it was never there in the first place. In this case, B's future interest is void, and so we cross it out. Remember, don't cross out the whole conveyance, just cross out the void future interest. And then we look at what's left and pretend that had been the original wording of the conveyance. So what does A have now? Well, it reads to A, so long as no liquor is ever sold on the premises, period. What does that sound like? Well, based on our previous analysis, we'd say that this time A has a fee simple determinable. And that's the right answer, but it's not the complete answer, because if A has a fee simple determinable, who else has what other interest? The answer, of course, is that O, the grantor, has a possibility of reverter, something that always accompanies a fee simple determinable. Now, you might say, well, there's no time limit on that either, but that doesn't matter because the rule against perpetuities doesn't apply to future interest created in a grantor, such as O's possibility of reverter in this case. So we have the kind of bizarre result that B's future interest is void under the rule against perpetuities, but the result is that O's future interest, which arises because B's was void, is valid because the rule doesn't apply to it. Strange, but that's the right answer. Now let's change the wording of the conveyance slightly and see how that can make a difference in the outcome under the rule against perpetuities. This time it says to A, so long as A personally never sells liquor on the premises, and if A does do so, then to B. When is B's executory interest certain to vest or fail? Well, the answer, of course, is it's certain to vest or fail within A's lifetime because A can't sell liquor after A has died. And so either A will sell liquor, in which case B's future interest is valid and will vest, or A will not sell any liquor during A's lifetime, in which case B's future interest will fail. But either way, it's certain to happen within or before the end of A's lifetime. So, bottom line, is B's executory interest valid or void under the rule against perpetuities? It's valid because it is certain to vest or fail within the lifetime of a person who was alive when the conveyance is made, namely A. We don't even need to put in the 21 years to make it valid. The 21 years would be available if we needed it, but in this case, it's certain to vest or fail within A's lifetime, and that's good enough to make it valid under the rule against perpetuities. Now, applying the wrap can be a little tricky. Let's take this example. To A for life, then to A's first daughter to reach age 25. Let's assume that A is living and has two daughters, both of whom are under 25. So the condition on the contingent remainder to the daughter hasn't been satisfied yet because neither daughter has reached age 25. Well, is it possible that A's first daughter to reach age 25 will do that? In other words, that the remainder will vest more than 21 years after the death of everybody who's now living. We're inclined to say, well, let's use the two daughters as measuring lives, and obviously one of them is going to reach age 25 during her own lifetime, and therefore the rule against perpetuities is satisfied. The problem with that is that if we assume that one of the daughters is going to reach age 25, we're also assuming that that daughter will not die before 25. Let's take a worst case example in which both daughters die before age 25, which is entirely possible, and then let's suppose that A has another daughter, one who isn't born yet, and who reaches age 25 more than 21 years after A dies. Is that possible? Well, it's absolutely possible. The result is that even if we use the two existing daughters as measuring lives, we can't make the remainder valid, and we can't use the daughter who actually might reach age 25 but hasn't been born yet because she isn't a life in being. Therefore, the only practical life we have left is A's life, and obviously A might have a daughter who reaches age 25 more than 21 years after A dies. So the bottom line is that the remainder is void. What do we do when we find a void one? We cross it out. We treat it like it never existed. So what's left simply says O conveys to A for life. That means that there is still a future interest, but it's no longer in the first daughter to reach age 25. Instead, the future interest is in O. O has a reversion, and because it is a reversion and therefore a future interest created in the grantor, it isn't subject to the rule against perpetuities, so it's perfectly valid. Now, a very minor variation in the wording of the conveyance can make a big difference in the application of the rule against perpetuities. Let's take a look at this one. To A for life, then to the first of A's now living daughters to reach age 25. Once again, we'll assume that A is alive and has two daughters, both of whom are under 25. Well, now, if we use the daughters as measuring lives, we're certain that either the remainder will vest in one of them during her lifetime, or it will fail because neither daughter reaches age 25. So is it possible that the A's first currently living daughter to reach age 25 will do that more than 21 years after the death of all now living persons? No, that's not possible, because if we use the living daughters as measuring lives, now we can make the future interest valid. And that's the conclusion. We don't need to cross anything off or strike out anything. The remainder is perfectly valid. Let's think about the impact of the rule against perpetuities on how quickly a piece of real estate can be sold in the open market. Let's go back to our previous example that said to A for life, then to A's first daughter to reach age 25. If this future interest were valid, in other words, if we didn't have a rule against perpetuities, how long would we have to wait before some person or small group of people who are alive could transfer good title to the land? Well, we'd need to have both the holder of the life estate, which is A, and the holder of the remainder, which is A's first daughter to reach age 25. We need to have them both join in the conveyance. We'd also have to have O join in the conveyance because O has a reversion in the event there isn't any first daughter to reach age 25. So we have to have three people to join in that conveyance. One of those people, namely A's first daughter to reach age 25, might not do so until almost 25 years after the end of A's life. So potentially we're waiting for the end of A's life plus as long as almost another 25 years. Instead, we apply the rule against perpetuities. Does that help? Does the RAP speed up our wait? Well, under the rule against perpetuities, the remainder of the first daughter to reach age 25 is void. All we have is to A for life and a reversion in O. Both A and O are living people. If they agree and join in a deed, we can pass good title immediately. So the rule against perpetuities definitely does, in this example, speed up the time at which a group of living persons can join together, execute a deed, and pass complete title to the real estate. We mentioned earlier that the rule against perpetuities applies to class gifts even if they're vested remainders. We haven't yet said exactly how it applies though, so let's do that. What the rule does is to make a class gift void if the class won't close. In other words, if no additional members can be added to the class. That has to happen within the rule against perpetuities period, which is 21 years after some life in being. Let's take an example of that. Here's an example that says to A for life, then to A's grandchildren. Well, the gift to the grandchildren, obviously, is a class gift. It's well, if A has any grandchildren at all, it's a vested remainder, but it's subject to open, and that's what we mean by a class gift. A could have grandchildren born much more than 21 years after A's death. That's obvious because A's own children could live a long time after A's death and then could have grandchildren born to them after that long period of time. That would seem to violate the rule against perpetuities. However, remember the class closing rule that we talked about when we discussed class gifts. The class closing rule says we close the class when anybody in the class is entitled to possession. So what that means is when A dies, if there are any grandchildren, we give the property to the grandchildren and we close the class and no further grandchildren can be added. All of that will happen when A dies. and therefore the rule against perpetuities is not violated. So the effect of the class closing rule that we talked about before is to accelerate the time when the class will close, and therefore to make it more likely that the rule against perpetuities will not be violated. It's very helpful in that regard. But remember that a grantor can evade the class closing rule by putting in language that specifically says that the grantor has a contrary intent. So let's suppose the grantor does that. The grantor conveys to A for life, then to A's grandchildren, including those who are born after A dies. That's a direct contradiction of the class closing rule that is our normal default rule. Let's assume A has 2 children and 1 grandchild. A could have grandchildren born much more than 21 years after A's death or after A's children's death, and therefore that will violate the rule against perpetuities. The result is that the gift to the grandchildren is void. We cross it off. All that's left is to A for life, and the grantor, of course, has a reversion. We mentioned earlier that the rule against perpetuities applies to options. We need to talk a little about what an option is before we see how the rule applies to it. An option is an offer to sell somebody some property. Now, it's not a completed contract. It's only an offer to sell, but it's coupled with a promise to keep that offer open for some time period. The optionee has to pay consideration for that promise, and the courts will then specifically enforce the promise to keep the offer open so that it does in fact remain open and can be exercised by the optionee, the purchaser, during the time that the option specifies. Suppose the option said, I hereby grant A the option to buy my land, we need to describe the land of course, for $200,000, and then we put in a time period, such as at any time during the next year. Of course, the time period might be much longer, such as at any time during the next 25 years. Or a very careless optionor might fail to put in any time period at all, and if there is no time limit at all, the courts might say that the option can be exercised indefinitely in the future. Now, we mentioned that an option is subject to the rule against perpetuities, just as certain future interests are. The courts assume that an option is sort of like a contingent remainder, and therefore is subject to the rule against perpetuities. Is that correct? Well, does it really create any interest in the land at all? I and many other scholars have long concluded that that's simply a wrong answer, that the rule against perpetuities should not apply to options at all because they don't create any interest in the land. An option's not a contract to sale. It's just a contract to make an offer and to hold that offer open for some period of time. Nevertheless, the majority rule is that the rule against perpetuities does apply to options. By the way, we mentioned a minute ago that a landowner might give an option that can be exercised many years in the future. That's possible, but is it smart? Well, the answer is it's almost always a very foolish thing to do because no one can predict what land prices will be very far into the future. Such a prediction is likely to be wrong as likely as it is to be right. And the truth is that any price that's placed on an option that can be exercised many years in the future is likely to turn out that the price will be inadequate and the landowner will be very disappointed that they granted it. Nevertheless, people can do it and sometimes do. Let's see how an option could violate the rule against perpetuities. Let's suppose the option says, I hereby grant A the option to buy my land, and we need to, again, to describe the land, for $200,000 at any time during the next 25 years. Notice that the death of the grantor and the death of A have no effect on the enforceability of the option. In other words, the option's enforceability isn't dependent upon either the grantor or A being alive when the option is exercised. If the grantor dies, the grantor's successors are still subject to the option. If A dies, A's successors are still able to exercise the option. So death has no significance in the usual operation of an option, and therefore trying to use lives in being simply don't help when we apply the rule against perpetuities. We can apply them, but there are no lives in being that make any difference. So an option for longer than 21 years violates the common law rule against perpetuities. And this very option is void under the rule because it can be exercised more than 21 years in the future, and indeed more than 21 years after the death of either A or the grantor. So why do we have a rule against perpetuities at all? Well, classically, there are two reasons that are given. The first one's one we've already talked about. The rule tends to prevent property from being tied up and practically unsaleable for long periods of time. The example we did with to A for life, then to A's first daughter to reach age 25 is an illustration of that. The property might be tied up until A dies and almost 25 years thereafter. So the rule against perpetuities makes the property saleable at a much quicker point in time. The other reason is that we have some reluctance to let the dead hand of the grantor dictate the future ownership of property for long periods of time. The feeling is that when people die, they shouldn't be allowed to say what's going to happen to the property a long time thereafter, and the rule against perpetuities helps to prevent that. Now, there's a widespread feeling that the rule against perpetuities is unduly complicated and difficult to apply, and so there have been a number of efforts to reform the rule and make it simpler and easier to understand. One of those, the one perhaps that's had the most widespread adoption, and this has been adopted in probably 25 or 30 states, is the Uniform Statutory Rule Against Perpetuities. This was a statute put out by the Commissioners on Uniform Laws and has been very popular. What it says is this: a non-vested property interest, that's a remainder, contingent remainder, an executory interest or a class gift, is invalid unless, when the interest is created, it's certain to vest or terminate no later than 21 years after the death of an individual then alive. Let me pause right there and say that number one there, that paragraph, is the statement of the common law rule against perpetuities. So the statutory rule, in a way, preserves and continues to apply the common law rule, but it also has an alternative. That's number 2 at the bottom of the screen. This is a different way in which a future interest that's subject to the rule might be held valid. And that is, if the interest actually either vests or terminates, vests or fails, we would say, within 90 years after its creation. So the Uniform Statutory Rule says that if the future interest in question would be void under the common law version of the RAP, what we do is wait and see if it actually vests or fails within 90 years, and if it does, it's valid. We refer to this as a wait and see rule, and as I said, a little more than half the states have adopted this. A few of the states that adopted it put in even much longer time periods than the 90 years. Nevada put in 365 years. I wonder where they got that. And Utah and Colorado both said 1,000 years. You'll notice that as a practical matter, when you put in a very long time period like that, you may as well simply repeal the rule against perpetuities. Those numbers don't make any sense or have any meaning as a practical matter. Who would lobby for this sort of rule? Who likes the idea that a future interest could be valid even though it would violate the common law rule? Well, the answer is that banks and trust companies love it because they love the idea that trusts can last for very long periods of time. And a trust is subject to the rule against perpetuities if its beneficial interests violate the rule. So many times a bank's trust that would be struck down under the rule could be validated under the statutory rule against perpetuities. At a minimum, they'll have at least 90 years to find out. Now, there are some other reforms, some other ways that the rule has been modified as well. One of them, and this is invented by the courts, is called the Cypre doctrine. What it says is if the court finds a future interest that is void under the rule against perpetuities, the court can reform the conveyance to make it comply with the rule. Basically, the court, in other words, can rewrite the conveyance so that it will pass muster under the common law rule against perpetuities. And courts in some states have been quite willing to do that. A second possibility is simply to repeal the rule against perpetuities entirely, and there have been a handful of states that have done that. A third possibility is to say, well, the real problem we're trying to address here is to make the property saleable in the market and to speed up the time when that will be true. So a possibility then is to repeal the rule against perpetuities for property that is held in trust as long as the trustee has the power to sell the property. Now what this does is to address the question of time when property will become marketable. It doesn't address the power of the dead hand to control the deceased owner's wealth after the deceased owner has died. That winds up our discussion of the rule against perpetuities. In our next video, we'll do an overall review of estates in land and future interests and try to see the big picture and how they all fit together. Thanks for watching. If you have questions or comments, email ProfDale01@gmail.com.